So last time we discussed all the way and we were left with the part before you on provisions with respect to unqualified persons acting as advocates and offences by advocates. So today we'll begin with section 31 of the Advocates Act that provides an offence for a person, for an unqualified person not to act as an advocate. So basically we said that we project the section and we provide what the various courts and decisions have held as regards to that section, and we read any exceptions thereto and where students confuse when it comes to examinations. So we have been told that section 31 means only a properly qualified or authorized person may act as an advocate in Kenya, and it says that if an unqualified person does so, they risk to face what we call contempt of court, and there is no right to claim fees or cost, and the same can also amount to criminal liability. So the carve-out is where another written law expressly allows a non-advocate to appear or act. This is known as the saving clause in section 83. Because if you look at section 31 of the Advocates Act, it starts by saying that subject to section 83, okay, the saving clause that enables any other law to permit any other person to duly appear as an advocate. For instance, members of a union can act as an advocate, but solely to prosecute a matter on behalf of the union, provided the same is a member of a union. So those are some of the saving clauses that the law provides. So in briefly, we have seen that any unqualified person who attempts to act so, and the same is not provided under section 83, the same will risk a contempt of court. There is no right to claim fees or cost before the honorable court in that matter, and you can risk criminal liability. What is the governing rule? So we can see that the core prohibition of the same is subject to section 83. No unqualified person shall act as an advocate or issue or process or institute or carry on defend in any suit in the name of any other person in any court, civil or criminal. Okay, what is the meaning of subject to section 83? Section 31 is overridden where some other written law permits an advocate to conduct, defend or act in legal proceedings, e.g. specific statutory tribunal frameworks. We have discussed that. Then we have discussed the separate consequences that a student ought to have at the back of their fingertips, because we have seen questions where students are told to describe the various consequences that that person acting as an unqualified person is subjected to. So those are the 3 points: contempt of court, the entitlement to sue for cost or fees for work done while acting unlawfully, and then it is a criminal offense. You can be prosecuted. Okay. So if you look at the general interpretation of who amounts to an unqualified person, this is anyone not recognized by law as entitled to practice as an advocate, practically not duly admitted or authorized to practice as an advocate, or otherwise not permitted by law to do that work. So the key determining factor that many students will get it wrong is that unqualified person can also be an advocate. Okay? If you read section 2 of the Advocate Act, the word "and" conjunctive, because it says that if you have met the requirement to be admitted as an advocate, and that person does not have a practicing certificate, that amounts to an unqualified person. So avoid the urge of thinking that an unqualified person is not an advocate. Admission alone is not proof, is not an exception for you not to be called an unqualified person. Okay, go read section 2. It is using the word "and" in a conjunctive manner. So practical application and how to use it. If someone is appearing or filing for any other person in a court case and they are not qualified as an advocate, cite section 31 and move the court to treat the conduct as unlawful. The court can also consider contempt consequences under section 31(2)(a) of the Act. If the unqualified person later demands legal fees or cost for that work, section 31(2)(b) blocks them from maintaining a suit to recover those costs. And section 40 also reinforces non-recoverability of costs in such circumstances. Okay? Before alleging breach, check the section 83 carve-out to identify whether the specific forum or proceeding is governed by a statute that expressly allows non-advocates to appear or act. Then let us look at section 32(a) of the Advocate Act. This is in regards to employment as in-house advocates. And generally what you need to understand is that, I can read verbatim, a person who is qualified to act as an advocate under this Act may be employed as an in-house advocate. A person who is employed as an in-house advocate shall, 1. Be an independent professional legal advisor to his or her employer, and B. Not charge fees for services rendered below the minimum prescribed fees under section 44. If you look at the professional ethics for last year, it tested a question on a person who was employed as an in-house advocate for a certain corporation, and this advocate was purporting to charge fees that were going below the minimum prescribed fees under section 44. So this provision is just basically telling you that if you are employed as an in-house advocate, you are still bound by the rules of the advocate remuneration order, and you are also bound to provide independent professional legal advice to your employer. Another technical question that a student can face is that you can be told that a certain advocate has been employed by a certain investor. Okay? Remember, many students will think that an investor cannot run a law firm. Okay? Many students will think that when an investor has employed an advocate, that is illegal. Okay? Let me tell you one thing, that our laws, if you look at the Advocates Practice Rules, Rule number 4, as read together with Rule 4A, amendment thereto, it says that an advocate who has been employed by an advocate, okay, in this case, it can be an investor. There are some stipulations of how some monies obtained or charged in that setup will be utilized. Exception number 1 is that to avoid a lot of people or private personnel opening a law firm and acting as touts on behalf of the advocate who has been employed, the Advocates Practice Rule premeditates the following, in that if you receive a salary, the advocate who has been employed by this an advocate person, that amount, the advocate will receive the salary that has been capped to what he is entitled to obtain. So that I cannot be speaking of rumors, I can directly read a blog that I did so that we be on the same page, because it is a very technical area and a lot of students can suffer greatly if the same question is asked this year. We have seen concepts like set-off, where the law firm makes a certain profit. The amount will be set off. Remember, this profit will not go to the investor, because the law does not provide for sharing of profits with an advocate. How is that amount going to be set off? It will be set off to compensate the normal running of the day-to-day activities of the of the advocate or the firm. Okay? Remember, it is a provision where if a question is brought to you, 90% of the students will fail. Okay, there is a blog that I did, almost, let me search directly, advocate practice rules. Good. This is it. This is it. Okay. So generally, the advocate practice rules, legal notice number 19 of 1967, provides that Rule 4 and 4A. Rule 4 provides for sharing profit cost with unqualified persons, with exceptions. 4A, advocate employed by an unqualified person barred from charging through employer legal services. We'll have a breakdown of it. There is a way that I broke it down. So take note, this is what I told the students. There is a very good rationale why Rule 4A was introduced. Listen keenly to the following discussion. It is a death trap if CLE gets you. Meaning and difference first. Rule 4 of the advocate's practice rules. An advocate must not agree to share profit cost from any professional business with any person who is not an advocate or qualified legal practitioner, subject to narrow exceptions, e.g., payments to a retired partner or dependents. 2. Limited set of arrangements for salaried advocates as specified in the rule. That was Rule 4. Then we saw another amendment that was introduced in 1984. Rule 4A. No advocate employed by an unqualified person shall draw documents or render legal services to that employer where the employer charges fees directly or indirectly to third parties and retains them. Okay? Statutory anchor. The same policy appears in Section 37 of the Advocates Act on sharing profits with an unqualified person. And understand the rationale. This will give you 3 marks. Why does it matter? Independence or conflict risk. An advocate profit participant can influence strategy, settlement, forum, or client choice. The other rationale is that we need to have consumer protection mechanisms. Clients may be steered to lawyers based on kickbacks rather than competence. Then, regulatory perimeter. This preserves the boundary that only regulated advocates earn legal fees for legal services mirrored by the criminal offense in Section 37 of the Advocate Act. Then I proceeded to tell the student that the fact is that you don't know the exceptions allowed under Rule 4. Rule 4 of the Advocates Practice Rules. An advocate must not agree to share profit cost from any professional business with any person who is not an advocate or qualified legal practitioner, subject to narrow exceptions, e.g., payments to a retired partner, limited set of arrangements for salaried advocates as specified in the rule. Then, if you go deeper, Rule 4 provisions list the exceptions. 1. Where the payment is being made to the retired or deceased partner's beneficiaries. That is an exception. 2. A sole practitioner may pay a retired partner or a predecessor. Okay, I've described that. Rule 4. Salaried advocate set-off. Where an advocate is employed by an advocate employer on salary to do the employer's legal work, the advocate may agree that profit costs recovered from opponents or third parties can be set off against A. the advocate's salary and B. the employer's reasonable office expenses incurred in connection with that advocate to the extent of salary and expenses. That is an exception. Many students will say that this profit is going to the employer. That is wrong. The extra expenses, let's say the advocate is to receive 100,000 every month, okay, as a salary. That is not illegal. He will be receiving that amount. But now, let's say the firm decides to do a bill of cost from a certain matter that they are going after a certain third party. And the bill of cost that has accrued for that month, let's say it comes to 200,000. So the law says that this 200,000 will be offset in two ways. One, the advocate who is subject to receive the 100,000 will receive his 100,000. The other 100,000 will still not go to the employer. The other 100,000 will be used to offset the expenses that were incurred in the normal operation of this entity. Explain Rule 4 provision further. I decided to give a situation so that students will understand. Advocate D is an in-house counsel at company X on salary. Advocate D runs litigation and the court awards party and party cost payable to company X. Okay? D and X have an agreement that such recovered costs are credited against D's salary up to salary amount. This is permitted because the rule allows set-off. So, D is not effectively earning fees on top of salary. Okay? Because you have seen here that a person who is employed as an in-house advocate shall be an independent professional legal advisor to his or her employer. Okay? You are an independent professional legal advisor. You are not allowed to earn fees from third parties. Okay? Set-off includes the following. Office expenses allowed but must be reasonable. Company X pays D's office overheads. Let's say it pays workstation, support staff, phone, filing, transportation, stationaries. Agreement allows recovered costs from third parties to be set off against salary plus reasonable offense. Therefore, this is permitted as long as the expenses are genuinely in connection with the advocate and are reasonable. Okay? Then one wonders how will they know all the above exceptions are being observed by the individuals? Is it a mere theory that the practice rules have decided to implement? And I went forward to give a prediction question that CLE can ask. CLE prediction question 2026 applicable. An advocate K runs a sole practice. 10 years ago, K took over the practice of a predecessor advocate M. Okay? So there is a predecessor advocate M under an agreement to pay M a monthly retirement annuity out of profits. But M has since died and K continues paying the same sums to M's widow as the legal personal representative. Then separately, K is employed part-time as in-house counsel by a transport company, not an advocate, on a fixed salary. In several matters, K recovers costs from third parties and opponents, and the company proposes that all such recovered profit costs be retained by the company to offset K's salary and office overheads and any surplus treated as company income. Advise K on whether these arrangements fall within the exceptions to Rule 4 of the Advocates Practice Rules and where the line is crossed into prohibited fee sharing, including any exposure under Rule 4A. That was the prediction question that I have predicted that can come this year. So if you have read that keenly in the way we started with analyzing the advocate practice rules, we can say that the payments being made to the predecessors of the former predecessor, okay, is permitted, and we have seen that. We can say that the amount being paid to offset case office overheads is permitted, but you cannot say that any surplus will be treated as company income because the rules are silent. That will amount to going overboard from what has been provided by the rules. Okay, then where K recovers costs from third parties, we have seen that K cannot earn from the costs that are recoverable from third parties because he is an independent professional legal advisor to his or her employer pursuant to section 32A of the Advocates Act. So those are the hidden nitty-gritties that you have to understand when you read this provision. So how have courts generally interpreted this provision? So this provision, now section 32A of the Advocates Act, legalizes in-house counsel employment for a person already qualified to practice as an advocate, and it had courts two conditions: one, professional independence in giving legal advice to the employer, and a restriction around charging or fee conduct linked to the statutory remuneration regime. Then, who can be in-house counsel? Only a person qualified to act as an advocate under this act may be employed as an in-house advocate. Okay. Looks like I've lost the document. Here it is. So I was still in section 32A. Okay. Judicial interpretation, what courts have actually done with this part. Employment relationship versus advocate-client billing. Where an advocate is engaged as an employee or legal officer in an in-house arrangement, they are generally not entitled to turn around and tax or charge the employer advocate's fees for work done within the scope of employment unless there is a specific agreement creating a separate retainer. Okay, that is an important point that you have to take away, is that once there is a retainer, you are not allowed to tax your advocate fees. You can see in the decision Anthony Thuo Kanai, trading as Thuo Kanai Advocates versus Canon Assurance Limited, 2020. Another key takeaway, my screen is sensitive. Another key takeaway is that public policy. Kenyan courts consistently treat the minimum fee regime as mandatory. I'm losing my screen. It is sensitive. Let me remove the charger. The screen is frozen. Just a minute. Let me open another tab so that it will work. Let me move using this one. Using this part. Okay, so we have seen another rationale that various courts have decided to bring on board, is that Kenyan courts consistently treat the minimum fee regime as mandatory. Agreements or conduct that result in charging or accepting below the prescribed scale are treated as unlawful or unenforceable. So remember, this is a target to the in-house advocates. Whenever an examiner tells you that the advocate purports to charge under the prescribed charging fees, that will be illegal. So the other key thing is that we have exhausted the key points that a student ought to have extracted from section 32, because we have delved deeper and linked the same to advocates practice rules, legal notice number 19. Okay, so we have section 32B of the Advocates Act. So generally it says that the Chief Justice, on recommendation of the Council of the Society, shall prescribe the standards of work that may be performed by a person employed as an in-house advocate under this Act, and the criteria for determining the remuneration payable to an in-house counsel by an employer. Okay. 2 says the employer of an in-house advocate shall not determine the remuneration of such advocate otherwise than in accordance with the criteria prescribed under subsection 1B. Notwithstanding subsection 2, the employer of an in-house advocate may, in making a determination under subsection 2, offer the advocate remuneration which is higher than that prescribed. And any person who contravenes subsection 2 commits an offense. How have courts interpreted this part? Currently there is no decision on that part, because it appears it is a straightforward provision. Section 33 of the Advocates Act, penalty for pretending to be an advocate. Any unqualified person who willfully pretends to be, or takes or uses any name, title, addition, or description implying that he is qualified or recognized by law as qualified to act as an advocate shall be guilty of an offense. Okay, this provision, section 33 of the Advocates Act, criminalizes holding out as an advocate by an unqualified person. If you're not legally qualified to act as an advocate, you commit an offense by willfully using any name, title, or description that implies you are so qualified. Okay, we can say that the enabling provisions, section 33 of the Advocates Act is the enabling provision. Then if you read section 9 of the Advocate Act, who is qualified to act as an advocate, where you have admission into the role of the advocate and you have a valid practicing certificate for that year. Remember, it is conjunctive, section 9 of the Advocates Act. Then section 31 of the Advocates Act, unqualified person not to act as an advocate because you will be subjected to contempt of court, offense consequences, and we have seen that you cannot recover cost arising in that in those matters. How have courts interpreted this part? Court treat practicing or holding out while unqualified as a serious illegality. Where a person purports to practice contrary to the act, courts may strike out the work and direct criminal investigation or prosecution. Mohammed Ashraf Sadiq versus Matthew Oseko, trading as Oseko and Company Advocates. Okay, where an advocate lacks a practicing certificate for a period, courts routinely hold the person was not qualified to act as an advocate in that period. Documents may be treated as incompetent or liable to be struck out depending on the context and the relief sought. But you can say that this is an older decision because it is a 209 decision, because this has now been cured by a Supreme Court decision on the same. If you read Anaj Warehousing and Dolo Ayar decisions, the same are authorities to that effect. Okay. How will the court prove an offense stemming from section 33? We say that they will look at the status. The accused person is he and an unqualified person is he on the roll, and if he is in the roll, does he have a valid practicing certificate for the period in question? Then conduct. Do you hold yourself out as an advocate? The accused pretended to be an advocate or used a title or description implying qualification. We can see that you try to use letterheads, business cards, WhatsApp profile, introduction to clients. That is risky. Then there is mens rea. It was willfully. You had the knowledge and intent, where we can infer the same from repeated representation, charging legal fees, filing documents, or continuing after being warned by the LSK. Section 34 of the Advocate Act. Unqualified person not to prepare certain documents or instruments. So it is important first to understand various instruments that are prohibited by this act. No unqualified person shall either directly or indirectly take instructions or draw or prepare any document or instrument relating to the following. 1. Relating to the conveyancing of a property. 2. 4. Or in relation to the formation of any limited liability company, whether private or public. Okay. C. An agreement of partnership or the dissolution thereof. D. Finding or proposing a grant of probate or letters of administration. Okay. E. For which a fee is prescribed by any order made by the CJ relating to any other legal proceedings. Okay. So generally, you have to understand various documents as have been listed before you that are directly prohibited by Section 34. Okay. Nor shall any such person accept or receive directly or indirectly any fee, gain, or reward for the taking of any such instruction or for the drawing or preparation of any such document or instrument, provided that this subsection shall not apply to the following people. Any public officer drawing or preparing documents or instruments in the course of his duty. Okay, they are exempted. Any person employed by an advocate and acting within the scope of that employment. Okay. 3. Any person employed merely to engross any document or instrument. So those are the people that subsection 34 will be exempted to. If you are a person employed by an advocate, a person merely employed to engross any document or instrument, or a public officer. Then, any money received by an unqualified person in contravention of this section may be recovered by the person by whom the same was paid as a civil debt recoverable summarily. So if a fact of a question tells you that a certain person decided to hold out himself as an advocate, and this mwananchi decided to send some legal fees to him, and then later it is discovered that this person was not a qualified advocate, okay, then we can say that Section 34, when we are giving remedies to this duped citizen, mwananchi, we can tell him that you can claim the amount that you sent to this person as a civil debt, okay, because it is provided for under Section 34(2) of the Advocates Act. Any person who contravenes subsection 1 shall be guilty of an offense. This section shall not apply to the following: a will or other testamentary instrument, or a transfer of stock or shares containing no trust or limitation thereof. At times, an examiner can decide to test various documents that were prepared by a certain person who was holding out himself as an advocate. So we can say that there are some exceptional documents that are not subjected to this section. If I'm Victor in my own capacity, then I was contracted by a certain client to draft a will or other testamentary instrument, then you cannot subject me to Section 34 of the Advocate Act. Then transfer of stock or shares containing no trust or limitation still will be exempted, and I believe these documents will be exempted because these are special documents on their own capacity, and they don't want to limit only advocates to draft the same. Okay. Section 34 of the Advocates Act bans non-advocate or unqualified persons, as we saw pursuant to Section 9 of the Advocate Act, from taking instructions or preparing specified legal instruments and from charging for that work. Money paid is recoverable summarily as a civil debt, and the drawer commits a criminal offense. Section 34 of the Advocate Act. Okay, we have also looked at the various documents that have been listed pursuant to that section. So what you have before you are just summary notes. Then let us see whether this section is to be linked with other section of the Advocate Act. If you read section 9 of the Advocate Act, we have decided to define who is a qualified person to act as an advocate. Then if you read section 34B of the Advocate Act, now post 2017, the validity of legal documents drawn by an advocate without a current practicing certificate is preserved, though it is a misconduct. Okay, so many students will interpret. In fact, if you look at the statistics that were done for last year's professional ethics paper, is that many students were quick to say that the legal documents will be safe, but they failed to give the misconduct that was arising pursuant to that act of drafting without a current PC, and those documents are as they have been listed pursuant to section 34. So you can have a certain concept in your head, but if you don't know the exceptions that arise from such principles or decisions, there is a likelihood that you will fail. So section 35 of the Advocates Act is also another section that says that endorsement of drawer's name or address registries must reject non-endorsed instruments. Okay, so we can say that there are some registries, for instance the land registries, they will not accept some documents taken before them for payment of stamp duty purposes if the same has not been endorsed by an advocate. Okay, so section 35 of the Advocate Act is also to be read together with section 34P. So why are we interpreting some judicial interpretation? Is because we have seen some CLE examination papers asking students to give rationale positions or ethical concerns arising from a certain procedure. So what's the purpose and effect of the public protection outlined by section 34 of the Advocate Act? This is aimed at protecting the public by prohibiting unqualified legal drafting for reward. Courts will not aid illegal fee recovery and may strike out claims for fees where the person was unqualified. So we can say that a certain rationale is arising here where the courts are trying as much as possible to prevent illegal fee recoveries. Because if I'm an unqualified person and I know that I can just decide to bring a matter before another person, prosecute the same, then recover cost, and I'll be given this cost, then we can say that that is a lacuna that the law will be promoting. So one rationale is that the court will not aid illegal fee recovery because you have seen you cannot recover the same. So documents or proceedings drawn or filed by an unqualified advocate, some decisions previously were saying that the documents will be struck out. Okay, but now the position has changed. We can say that the Supreme Court held that section 34(1)(a) does not automatically render a conveyancing instrument void for all purposes merely because the advocate lacked a practicing certificate. The statute primarily penalizes the advocate and provides civil or criminal sanctions. National Bank of Kenya Limited versus Anaj Warehousing Limited 2015 decision at the Supreme Court. How is section 34 used? What conduct is prohibited? You need to understand that. Is there any drawing of documents? Is there any receipt of payment? Is there any instructions? Okay, so these are the final touches of how I try to synthesize a certain provision of the law. Then if we read section 34A of the Advocate Act, additional endorsements. Subject to Section 10 of the Advocate Act, an advocate who holds a current practicing certificate shall not file any legal documents in any registry under any law which requires filing of such document by an advocate, or issue such document for any other professional purpose unless there is affixed on each such document the stamp or seal issued by the society under Section 23(2)(a). Basically, Section 34(a) of the Advocates Act is a mandatory LSK stamp or seal filing it. Even a properly qualified advocate with a current practicing certificate must not file or professionally issue any legal document that a law requires to be filed by an advocate unless that document bears the LSK stamp or seal for that advocate for that year. So generally, we can say that Section 34(a), a current PC advocate shall not file in any registry where filing by an advocate is required or issue for any professional purpose unless each document has the LSK stamp or seal issued under Section 23(2)(a). Okay. Then LSK must, if you read Section 23(2)(a) of the Advocates Act, it says that the LSK must issue every registered advocate a stamp or seal bearing the name, admission number, and year of practice to be affixed on every document drawn and lodged for registration or issued for professional purpose. We have seen in some court proceedings where some law firms have a stamp that says this is my practicing number, this is my name, and this is my admission number, and even the year, the current PC year, it is indicated. So generally, that is an administrative role. And CLE can even twist a question from there. So Section 34(b). So if you are keen Section 34, we have seen we have Section 34, unqualified persons not to act as advocates, as unqualified persons not to prepare certain documents or instruments, okay, 34. Then we have seen 34(a), additional endorsements, and then we have seen 34(b). What will be the validity of the legal documents? Remember, this was an amendment that was introduced after the Supreme Court decision. If you look at the Legal Notice 11 of 2017, a practicing advocate who is not exempt under Section 10 and who fails to take out a practicing certificate in any year commits an act of professional misconduct. Okay, so if you have been told that there is an advocate who works at the BPP's office, AG's office, we can say that the people, the advocates employed there, will not be subjected to a professional misconduct route because they have been exempted. They can draft, they can practice for that year, and you cannot attach the mandatory practicing certificate for that year to their neck. So another angle that you need to take note is that advocates who act on behalf of county governments, the county attorneys, can be taken to the tribunal. They are not exempted. They can be taken to the advocates disciplinary tribunal. The other exception, before the ADT tribunal, we saw that the senior advocates, not senior advocates, senior counsels will be subjected to a separate committee to be appointed by the Chief Justice, because we will have a look at the same person to this act. So those are the nitty-gritties that you need to have at your fingertip. So notwithstanding any other provisions of this act, nothing shall affect the validity of any legal document drawn or prepared by an advocate without a valid practicing certificate. For the purposes of this section, legal document includes pleadings, affidavits, depositions, application deeds, and other related instruments filed in any registry under any law requiring filing by an advocate. So generally, Section 34(b) reverses the old or nullity strikeout approach. An advocate's failure to hold a current practicing certificate is now expressly treated as professional misconduct, but it does not invalidate invalidate the pleadings or affidavits and deeds or other legal documents they drew or prepared as against the client or third parties. So key takeaways is that section 34B is that if an advocate is not exempt under section 10 and the same advocate fails to take out a practicing certificate for any year, this is a direct professional misconduct. Section 34B2, notwithstanding any provisions of this act, validity of any legal document drawn without a valid PC is preserved. Then legal documents will include pleadings, affidavits, depositions, and application and deeds. Okay, interaction with the stamp and seal requirement, as we saw under section 23 of the Advocate Act, will also be applicable because the same requires an advocate with a current practice certificate to affix the LSK stamp or seal on documents filed. So this is the rationale. So Supreme Court decision, National Bank of Kenya Limited versus Anajwe Housing Limited, is the landmark decision there too. So we also saw a recent decision known as the Department of Agriculture and Food Authority versus George and 4 others 2022, where preliminary objection was dismissed and courts can order personal cost against the advocate who did not have the current PC. So limit of the protection, section 34B does not rescue documents or drawn or filed by a suspended advocate. Okay. Listen attentively. This is why I say that if you understand the statutes that have been laid before your cause outlines, you will never go wrong. CLE can say that a certain advocate has been suspended for 2 years. There was a complaint before the ADT tribunal. Do you know the difference between the ADT and the ACC commission? We will have a look at the same. An advocate has been suspended, and that advocate has proceeded to draw some documents, and he has even filed for the honorable courts. So remember, don't rush to say that those documents will be rescued. Those documents are void ab initio. Suspension is different from no PC. Okay. What is the other rider that you need to master? That was it. That was a trick that CLE can implement. Instruments to be endorsed with name and address of drawer, section 35. Okay, so generally, because this is now administrative, I'll not delve much. So section 35 of the Advocates Act is a mandatory drawer identification rule. Every section 34(1) instrument must show who drew it. Remember, we have seen various instruments that cannot be drafted with unqualified persons. Okay, so as a rationale to curb out the masquerading people, you need to endorse those documents with the name of the person who duly drafted the same. This is captured under section 35 of the Advocates Act. Okay, so generally, failure to observe the same is an offense, and the fine is capped at 5,000 for unqualified persons or 500 for advocates. If an employee draws or prepares or engrosses within scope of employment by an advocate or firm, the endorsement must be by the advocate or firm's name or address. And we have seen that the Chief Land Registrar, County Land Registrar, Registrar General, Registrar of Companies, and any registering authority must refuse to accept or recognize any Section 34(1) document unless endorsed. Okay, so the link is that Section 34(1) covers conveyancing, company formation, partnership, and probate filings, and CJ fee documents under Section 44, and documents relating to legal proceedings. So those are the documents that if you are not an advocate and you are purporting to draft the same, you should endorse your name, and failure to do so, a registrar must refuse. It is mandatory for them to refuse to recognize those documents. If you approach the Adi House for franking, what we call franking is the assessment fees for the stamp duty that you must pay, either in relation to company formation, partnership formation, probate formation. We have also seen conveyancing documents, e.g. a transfer. You must go there for franking. This is the rationale that is being brought by section 34. Every registrar will return you back to tell you that kindly go and appear before an advocate, and this advocate should list down their particulars. Okay, so I've said that is administrative, and we have seen it is an offense and it carries some penalties and fines. Undercutting. Section 36 of the Advocates Act. Any advocate who holds himself out or allows himself to be held out, directly or indirectly, and whether or not by name, as being prepared to do professional business at less than the remuneration prescribed by order under this act shall be guilty of an offense. No advocate shall charge or accept, otherwise than in part payment, any fee or other consideration in respect of professional business which is less than the remuneration prescribed by the advocate's remuneration order under this act. Okay, so generally, when it comes to practice, we have seen situations where if you are an advocate and you don't want some clients to go spreading out your name at you are undercutting, you just write the name interim fee note. No, in fact, one thing that you are told in this profession, never issue out to a client a final fee note immediately after you have received instructions. It is dangerous because you will have undertaken to pursue this matter. Maybe you have inserted in the fee note or the instruction note thereunder that I will duly represent you all the way to the Court of Appeal if any appeal arises. Okay, and then you went ahead to say that this is the final fee note. In this final fee note, in one or another, you have a conflict with the client. This client rushes to the LSK. They ask one thing: is this fee note final or interim? Is it, if it is final, is it under the prescribed remuneration orders? And maybe at that time you never intended for it to be final. You just wanted it to capture just a deposit amount. LSK is seeing that this property is worth 1 billion. You are charging this client 80,000. You are demeaning the profession. It will be a professional misconduct. So you are always told to issue interim fee notes because 36(2) allows that. No advocate shall charge or accept otherwise than in part payment. Okay? So no one can tell you that that is illegal. You have been protected by section 36(2), otherwise than in part payment. Interim fee notes are part payments. So that is a trick that I have told you. Section 36(1) of the Advocate Act, it generally discusses about advertising or holding out. Offense to hold oneself out, either directly or indirectly, named or unnamed, as prepared to do professional business at less than the prescribed remuneration fees, is an offense. Then the prescribed remuneration is usually set through the Chief Justice power to make remuneration orders pursuant to section 44 of the Advocates Act. Okay, then you have what have courts interpreted pursuant to section 36 of the Advocate Act. So agreements or arrangements that amount to fees below scale are treated as statutorily prohibited and may be held unenforceable unless they fall within what the remuneration framework permits, e.g., compliant advocate-client fee agreements. If you look at the decision Kahari and Kiai Advocates versus Kenya Safari Lodges and Hotels, you can, for remembrance, Kiai Advocates versus Safari Hotels. Okay, 207. Ratio decidendi. The court held that there was no valid and binding agreement on fees between the advocate and the client because the alleged agreement was not in writing and signed by the client or their authorized agent, as required by Section 45(1) of the Advocates Act. Even if such an agreement had existed, it would have been invalid and unenforceable under Section 46(d) and Section 36 of the Act, which prohibit advocates from accepting fees below the prescribed scale. The court further found that the taxing officer erred in principle by calculating item 1 of the bill of cost under the wrong part of Schedule 1. So the enabling parts are irrelevant to what we are discussing. The application for stay was refused as there was no longer any basis for it following the court's determination of the reference. Each party was ordered to bear its own cost. So the key takeaway that I wanted us to take is that even if there is a written agreement pursuant to Section 45(1) of the Advocates Act, even if that agreement existed and it still charges way below the advocate's remuneration order, then that agreement will be invalid. So the High Court has also recognized that Section 36 of the Advocates Act prohibition operates within the broader remuneration regime, including the remuneration order and the advocate-client fee agreement provisions, i.e. you don't read Section 36 in isolation. If you read the decision known as Ahmed Abdikadir and Company Advocates versus NBK Limited, 206 decision, ratio decidendi was that the court held that while Section 36(1) of the Advocates Act prohibits advocates from charging less than the prescribed remuneration, this prohibition is qualified by the advocate's remuneration order, which allows advocates to negotiate fees with clients where the assessed remuneration exceeds 10,000. Section 45(1) of the Advocates Act further authorizes such agreements, provided they are in writing and signed by the client. In this case, the fees in question were in excess of 10,000 and there was no evidence that the agreement was otherwise illegal or contrary to public policy. Therefore, the plaintiff's claim was not founded on an illegal act and the application to strike out the plaintiff had no merit. So there is a rider. Remember, this is a 206 decision. I can beg you to read the full decision so that you understand the basics of why this ratio decidendi was held. So generally, we can say that one thing we can take key notice that Section 45(1) of the Advocates Act further authorizes agreements provided they are in writing and signed by the client, where the fees in question were in excess with a certain amount. So we can say that parties can negotiate their way out, but you can never negotiate your way to go below the remuneration order. You can always negotiate above, but never below. Okay. So what is the key takeaway here? Marketing trigger, fee discount adverts. If you ever see a question that the examiner says that there is a fee discount advertisement, or there is a tender proposal, or we do conveyances at Kenya shillings X flat, where X is below the applicable scale, then you have offended the Advocates Act Section 36 on undercutting. Remember, after we have finalized on this, we will do the second session on SOPEC rules, because we were to go now under conflict of interest, SOPEC number 7. Conflict of interest is SOPEC number 6, then confidentiality 7. We will confirm that. So we will do now a merger between SOPEC on its own and how the same will be relating to the Advocates Act. One thing about the Kenya School of Law program is that you are not expected to cram the specific provisions or rules, provided you have the contents and exceptions. Sharing profits, Section 37 of the Advocate Act. Any advocate who agrees to share his profits in respect of any professional business, whether contentious or non-contentious, with any person not being an advocate or other duly qualified legal practitioner by whatever name called, shall be guilty of an offence, provided that this section shall not apply to the payment of any bonus to any of his employees by an advocate, being a bonus based or calculated on the advocate's total earnings or profits in respect of that period or any period. Okay, so we can say that this section is telling us that even if a matter is not contentious or it is non-contentious, we saw this question actually being tested last year when a person had brought a matter to an advocate, and this person was demanding a certain portion from the same. So this was an agent, he was touting, and then there was breach of now section 37 on sharing of profits. Okay, so always remember that if the advocate does not have a current PC for that year, the same advocate will still be counted as an unqualified person. Okay, so you cannot share profits with that person. So section 37 of the Advocates Act makes it a crime for an advocate to share profits from legal practice with an advocate, whether there is fee splitting or fronting. Okay, an example of a fronting situation is where there is an advocate, but that advocate maybe has left the jurisdiction of Kenya, maybe he has ventured into other things, but you are using the name of that advocate as if he is the one running that office. That is fronting. And if you continue to share the amount to that person, that is because maybe at that time he does not have a current PC, that will be sharing profits with an unqualified person. Okay, so the only exception that we can say that is arising from section 37 of the Advocate Act is where the advocate is paying employees a bonus. Okay, so the general rules, section 37, I will not repeat what I have explained. What have various courts decided? Allegation must be proved. Employees can interact with clients without fee sharing. The High Court rejected an attempt to defeat an advocate's fees by alleging breaches of section 37 to 40, where the evidence did not show fee or profit sharing. It accepted that employees may do support work and deal with clients within employment. Okay, so hapo kuna client who wanted to evade payment of fees. So if a partner is unqualified or does not have current practicing certificate, the firm can be treated as illegal and is entitled to fees. Section 37 is used to attack the arrangement. The court held that a firm with a partner who was unqualified or did not have practicing certificate offended the Act, including section 37, and could not recover fees or costs. Jimmy Agri-Simiyu versus Elizabeth Wanjiru Evans 2019. The ratio decidendi was that the court found that B.W. Mathenge and Company Advocates was an illegal entity because one of its partner, Beatrice Wambui Mathenge, had not held a valid practicing certificate since 2009, rendering her an unqualified person under the Advocates Act. So section 37 prohibits a qualified advocate from sharing profits with an unqualified person, and section 39 prohibits an advocate from acting as an agent for an unqualified person. Okay, so I want you to see how these sections intermarry with each other. So section 36 says that you cannot share profits with an unqualified person. Section 9 says provides the various tests to know if this is an unqualified person. Okay. Section 39 tells you that it is an offense where an advocate shares, where an advocate acts as an agent for an unqualified person. Okay, so those are the key takeaways that you need to have at your fingertips. So the court held that any legal documents, including the bill of costs drawn and filed by such an illegal entity, are null and void. The taxing master's decision to tax the bill of costs in favor of the respondent was therefore set aside. The court further declared that the firm could not recover any cost or fees for matters instituted in its name, as its existence contravened the Advocates Act. The applicant was entitled to cost of the application, and I'm sure the advocate faced professional misconduct if a complaint was taken before the tribunal, because the tribunal says any person can bring a complaint. It does not specifically say that this person ought to have been a client or be acting in that matter. Okay. So how do you apply Section 37? Referral commissions to non-advocates tied to legal fees collected. Arrangements where non-advocate introducer gets a percentage of instruction fees, retainer, or recoveries. This was tested last year. Partnership profit share in a law firm with a non-advocate or an unqualified advocate. It's also another situation where you can be tested on. Using an advocate's name or firm to bill while profits are for a non-advocate often overlaps with Section 39 on acting as agent for unqualified person. So Section 39, an advocate should not act as an agent for unqualified person. That's why I read the advocate practice rules, where we saw a situation where an advocate now has been employed by an advocate. Okay, so we are being told in this situation, if this advocate, okay, if this entity, BMW Madenge and Company Advocates, we are two partners, and in our partnership, my colleague has never taken out his practice certificate since 2009 or 2003 huko, all the way to 2026, and I purport to do a bill of cost to the respondents to obtain some cost. So one angle that we will be attacked with is that we are an illegal entity. The act is very harsh. The various landmark decisions are very harsh in terming the law firm as an illegal entity, because it is a partnership. Okay. So what is allowed within the provision is that paying a bonus is allowed. We have also seen that employees can interact with the clients, provided it is within the employment scope. So client asiende kusema that the law firm is sharing profits with an advocate. That is under the scope of my employment. So that is it. Section 38, touts. Any unqualified person who, in consideration of any payment or other advantage to himself or any other person, procures or attempts to procure the employment of an advocate as such in any suit or matter, or solicits from an advocate any such payment or advantage in consideration of such employment, shall be deemed to be a tout for the purposes of this section. The Chief Justice, if satisfied that any person has acted as a tout, by order excludes such person from the employment by an advocate in his practice as such. Okay. Let me tell you one thing that can also affect you. If you have a chance to be employed in a certain law firm, you are just a clerk, and this advocate is found guilty by the tribunal. We have seen, while I was interpreting this statute, I saw a provision that says that the advocate who has been suspended must disclose to any place that is making an employment or a request that I have been duly suspended. Only one. So automatically it says that itakuwa ngumu wewe kupata kazi mahali kwingine juu they will have a bias. The other angle is that the clerk who was acting for this advocate who has been struck out, okay, will not be entitled to ever work in any other advocate's office, and his name or her name shall be gazetted, where we will see that provision. So an examiner pia anaweza kindly advise the following people: maybe sasa hiyo ni situation umepewa, realize there are some misconduct, then unaambiwa the tribunal so it deem fit to strike this person out, kindly give the exceptions there to huyu clerk atafanyiwa nini. People never read to that extent. Okay, and if you want your name to be to now be eligible to be employed by other advocates, you have to write to the CJ. Okay, and then if the CJ decides to see otherwise, then you can be now cleared off. Now you can be employed by fellow advocates. Okay. So now the Chief Justice may, now this is now pursuant only to Section 38. The Chief Justice may, if satisfied that any person has acted as a tout, by order, exclude such person from the employment by an advocate in his practice as such. So tuseme mimi ndio natumika kama tout, then a complaint is lodged, the advocate is found guilty, I will also not be spared. I will never be employed by another advocate. Then when you are doing your privilege, and you want to now gazette, you want to petition to the CJ to duly gazette your name. You remember there is a period where if any complaint is lodged against your name, however little it is, wanasema they must listen to it before anything, so utakuwa delayed with 1 year. So it is always recommended that keep your staffs private. Any person can lodge a complaint, remember. Haya, so section 39. So section, after tumemaliza, we will have now briefly tutasema tu generally section hii na provide so that it sticks to your minds. So section 39 of the Advocate Act. Advocate not to act as agent for unqualified person. Any advocate who acts as an agent in any suit or in any matter in bankruptcy for any unqualified person, or permits his name or that of any firm of which he is a partner to be made use of in any such suit or matter upon the account or for the profit of any unqualified person, or who does any other act enabling an unqualified person to appear, act, or practice in any respect as an advocate in such suit or matter, or who is in any way assisting any unqualified person in any cause or matter in which he knows that such person is contravening or intends to contravene this act, shall be guilty of an offense. Okay, so an advocate should not act as an agent for unqualified person. Okay. Section 39 makes it a criminal offense for an advocate to front for an advocate. You cannot run a case in your name or your firm's name for the account or profit of an unqualified person, or do anything that enables or assists an unqualified person to appear, act, or practice as an advocate. Governing rules, Section 39 of the Advocates Act. An advocate is guilty of an offense if they 1. Act as agent in any suit or bankruptcy matter for an unqualified person, they permit their name or their firm to be used as such, do any other act enabling an unqualified person to appear or act, okay, assist an unqualified person in cause or matter where the advocate knows the person is contravening or intends to contravene the act. So judicial interpretation. Fronting makes the practice structure illegal and disentitles the firm to fees and costs. Okay, so fronting pia inaumiza fellow partners, so it is injurious even to the firm itself, where a firm's arrangements amount to an advocate sharing profits or acting as agent for an unqualified person. The court can declare the entity illegal and bar recovery of cost. B.W. Mathenge and Company Advocates, 2019. So allegations under section 37 all the way to 39 must be proved. Employee support is not equivalent to acting as an agent for an unqualified person. Courts rejected a client's attempt to defeat fees by alleging touting or fee sharing or agency without evidence of profit sharing or masquerading. Employees may interact with clients and prepare documents within employment with proper endorsement that carries the endorsement of the firm, as we have seen in Section 23 of the Advocates Act. Okay. Courts will sanction unqualified practice plus aiding or abating scenarios heavily. Where a lawyer or firm structure is used to facilitate unqualified practice, the court may strike out proceedings and direct criminal investigations or prosecutions under the Advocates Act framework. Person 2, Mohammed Ashraf Sadiq, trading as versus Matthew Oseko. Okay, so those are the nitty-gritties. So nitty-gritties. Section 40. No cost recoverable where unqualified person acts as an advocate. One thing that I love with analyzing a statute is that you will never realize that, in fact, when you read a certain decision, you have almost read the whole act, because we have encountered Section 40 in almost all of the offences where an unqualified person was acting. So it will stick to your mind in that regard. So no cost in respect of anything done by an unqualified person in contravention of this part shall be recoverable in any suit or matter by any person. So Section 40 is a hard no cost sanction. If any work in a suit or matter was done by an unqualified person in breach of this part of the Act, nobody can recover costs for that work in that suit. Okay. Governing rules. Read Section 40 of the Advocates Act. Read Section 31 of the Advocates Act, where we saw contempt of court, incapacity to sue for cost, and amounts to an offence. Read Section 39 of the Advocates Act, where it is an offence to front your name on behalf of an advocate, of an unqualified person. If you're an advocate and you're acting as an agent for an unqualified person, that is fronting. That is acting as an agent. Section 39. Okay, so in all those situations, you cannot recover the fees. Courts have refused to allow recovery of fees. Okay, that is a retaliation. B.W. Mathenge and Company Advocates. Okay. Mere suspicion, where it is an employee interacting with the clients, mere suspicion is not enough. Remember, this is my scope of employment. Section 41. Employment by advocate of persons struck off the roll or suspended. No advocate shall, in conjunction with his practice as an advocate, without the written permission of the Council of the Society, which may be given for such period and subject to such conditions as the Council thinks fit, employ or remunerate any person who, to his knowledge, is disqualified from practicing as an advocate by reason of the fact that his name has been struck off the roll, otherwise than at his own request, or is suspended from practicing as an advocate. So we have seen that if a person has been struck off the roll or has been suspended, then you go to another advocate to employ you. Remember, you should disclose that you have been suspended and struck off, so that this person, this advocate who wants to employ you, should write to the LSK so that they can be given permission to employ you. No. An advocate aggrieved by the refusal of the Council of the Society to grant any permission referred to subsection 1, or by conditions attached by the Council to the grant thereof, may appeal to the Chief Justice. Okay, so hapo pia mimi nilikuwa nimeruka a key step. First thing, write to the Council of the Society, so Council of the Law, LSK Council. Then, if you want, wakikunyima the permission to employ this qualified person, appeal to the Chief Justice. So basically inakuonyesha tu utakosa kazi once you have been struck out or suspended. If any advocate acts in contravention of this section or of the conditions subject to which any permission has been given thereunder, he shall be liable to proceed under Section 60. Section 60 is umbrella provision, professional misconduct. If you ever see a professional misconduct question, if you read Section 60, inakwanga direct imejibu that aspect of professional misconduct. So if I realize that a person has been employed by a certain advocate, no advocate amekuwa struck out from the role, so you can say that I can lodge a complaint now to that law firm. Kwa nini wameemploy mtu amekuwa struck off without written permission from the council or an appeal from the Chief Justice? So basically, ukisoma na language that is easy to understand, an advocate must not employ or pay a struck off or suspended advocate in connection with legal practice unless the LSK council gives written permission. Breach exposes the advocate to disciplinary proceedings and sanctions under the Advocates Act, Section 41 of the Advocates Act. Okay. Failure, breach, you are liable to proceedings under Section 60. Section 60 ndio hii inasema complaints of professional misconduct to the disciplinary tribunal. Okay. Sanctions include admonition, suspension, striking off, fines, and compensation. You can encounter a question in yetu inataka marks 3. Kindly give various sanctions that a certain person amepatwa akifanya makosa akapelekwa to the disciplinary tribunal can be subjected to. Sanctions include admonition, suspension, striking off, fines, and compensation. Key takeaway: remember, disciplinary tribunal can also award cost, but cannot award a stay of its own decision. Where do you seek stay of a decision passed by the disciplinary tribunal? At the High Court. Okay. Tight companion provision. Section 42 of the Advocates Act criminalizes the struck off or suspended person who seeks or accepts such employment without first disclosing the disqualification. Remember, I told you that if you have been struck off or suspended from the role of advocates for a certain year or years, it is a duty. It is a duty for you to disclose to the potential employer. Failure to, it is a criminal offense pursuant to Section 42 of the Advocates Act. So employer anaweza kuruka. Employer anaweza kwambia mimi hujaniambia kitu. Where is the evidence? Write an email to tell him that you have duly notified him you have been struck off from the role. It is now his duty to write to the LSK council. Failure to, wakikunuma, appeal to the Chief Justice. Section 42 of the Advocates Act. Penalty for failure to disclose fact of having been struck off, etc. Any person who, whilst he is disqualified from practicing as an advocate by reason of the fact that he has been struck off the role, otherwise than at his own request, or is suspended from practicing as an advocate, seeks or accepts employment by an advocate in connection with the advocate's practice without previously informing him that he is so disqualified as aforesaid, shall be guilty of an offense and is liable to a fine not exceeding 50,000 shillings or to imprisonment for a term not exceeding 2 years or to both. So at times utapata swali inasema give the various sanctions that can be given to this advocate. 50,000 shillings, imprisonment not exceeding 2 years, and both. So Section 42 makes it a criminal offense for a struck off advocate not at own request or suspended advocate to seek or accept work in an advocate's practice without first disclosing that disqualification to the employing advocate. It's a criminal offense. So Section 42(1), offense is committed where a person, while disqualified from practicing as an advocate because they have been struck off, so hiyo ni repetition. Offenses by bodies corporate, Section 43 generally inasemaje, if any act is done by a body corporate or by any director, officer or servant thereof, so inasema kitu hapo, recognized by law as qualified to act as an advocate, the body corporate shall be guilty of an offense and liable to a fine not exceeding 50,000 shillings for each such offense. And in the case of an act done by any director, wacha nisome vizuri, pia inaweza iko very relevant. Offenses by bodies corporate. If any act is done by a body corporate or by any director, officer or servant thereof, of such a nature or in such a manner as to be calculated to imply that the body corporate is qualified or recognized by law as qualified to act as an advocate, the body corporate shall be guilty of an offence and liable to a fine not exceeding 50,000 shillings for each such offence. And in the case of an act done by any director, officer or servant of the corporation, he shall, without prejudice to the ability of the corporation, be guilty of an offence and liable to a fine not exceeding 25,000 shillings for each such offence. In this part, references to unqualified persons and to persons include references to bodies corporate. Okay, imply that there is qualified. So basically inakwambia a body corporate in its own capacity can be fined, okay, where it purports to act, and it shall be guilty of an offence and liable to a fine not exceeding 50k. Alafu wakipata kuna an act that was done by director, officer or servant of the corporation in a capacity, in their own capacities, watakuwa subjected to a fine not exceeding 25,000 for each such offense. So student asiseme pale mambo ya nini, they are protected by the corporate entity itself. Section 43 says otherwise. Remuneration of advocates. So generally hii ni administrative. Can there be any question arising from here? So basically section 44 empowers the CJ on LSK Council's recommendation to set the binding fees regime for advocates. This is very administrative. Where there is a valid advocate-client fee agreement under section 45, taxation is generally hosted and the agreement governs. Where no valid agreement exists, remuneration is ascertained by taxation under the remuneration order. You can never do two at the same time. If you have a binding agreement under section 45, forget about taxation. If a dispute arises from the fee agreement, hapo sasa you can go to court for the interpretation of the agreement. Then if it is found that they violate, the extra on the demanded amount can be subjected to a taxation, or you can be told to do taxation. Then the amount inatoka una offset the balance alafu unabakisha yako. So I'm looking on okay hapa. Section 45 of the Advocates Act on topic ni agreement with respect to remuneration. Interpretation inasemaje? Section 45 lets advocate and client contract out of taxation by signing a written fee agreement, but the client can attack it by chamber summons within the section 45(2)(a) timelines. And the High Court, a judge sitting with two assessors can uphold, vary, set aside or send the costs to taxation. So this is the point that I was saying. A client can attack the written fee agreement through chamber summons. Okay? And the High Court will sit and uphold or vary or set aside and or send the cost to taxation. So generally, Section 45 of the Advocates Act is on validity of agreements, fixing remuneration or instruction fees, appearance fees, or fees for criminal or court-martial are valid and binding if in writing and signed by the client or duly authorized agent. Challenge client may apply by chamber summons to set aside or vary if harsh and unconscionable, exorbitant or unreasonable. Person to Section 45(2). Then court will sit with two assessors, advocates with post-qualification years of 5 years. Time bar. Application must be brought within 1 year of the agreement or within 3 months of a written demand for payment or fee note or otherwise, whichever is later. Okay. So effect on third party cost. Agreement does not change what is payable or recoverable as between the client and other parties, but client cannot recover from the other side more than what the client owes their advocate under the agreement. Okay, so hapa kwa time bar, if an examiner asks you a question that there is a dispute between a client and an advocate in regards to a certain written fee agreement, remember the remedy to tell the client. 1. Look at the timeline. Are you within 1 year or are you within 3 months after you have been served by the demand to pay by the advocate? If you have been served with a written demand, do an application to seek extension of time, okay, to bring this chamber summons application. So you'll have an application seeking extension of time, then you draft the chamber summons, okay. Then within 3 months kama umepewa demand, but within 1 year, okay, of the agreement. Haya. So effect on the party cost. Agreement does not change what is payable or recoverable as between the client and other parties, but client cannot recover from the other side more than what the client owes their advocate under the agreement. Okay, so you're bound by the agreement. Guardians or trustees. Advocate must seek court approval by chamber summons within stated time where the client signed as a guardian or trustee. Okay. Masikia maneno. If there is a written fee agreement, and in this written fee agreement, the same has been signed by a client as a guardian or trustee. Okay, person to section 45(4), where any agreement made by virtue of this section is made by the client as the guardian or committee of or trustee under deed or will for any person whose property will be chargeable with the whole or any part of the amount payable under the agreement, the advocate shall, before payment thereunder is accepted or demanded in any event within 6 months after its due date, apply by chamber summons to the court for approval of such agreement, and every such application shall be dealt with in accordance with subsection 2 that says an application under subsection 2 may be made within 1 year. Hiyo tumeongelea by chamber summons. Okay, so ukipata facts that you have been told that a person was acting as a guardian, akasign a written fee agreement or a trustee, the advocate must seek court approval, okay, for the agreement to be adopted as valid. Change of advocate, death, incapacity. Court can set aside or vary if client changes advocate without good cause, and court tends to allow the advocate the full agreed remuneration. Section 45(5). So if the client decides to change an advocate without good cause, so the advocate will still be eligible to get the full agreed remuneration. No taxation. Where a section 45 agreement exists, costs are generally not subjected to taxation, nor section 48 subject to section 45 itself. Okay, so where a section 45 agreement exists, costs are generally not subject to taxation, nor section 48 subject to section 45. Haya. Civil procedure rules. Order 52 Rule 3 requires a section 45 application to be instituted in the matter of the Advocates Act and supported by affidavit. Order 52 Rule 3. Time limits are enforced strictly. If filed outside 1 year or 3 months, whichever is later, the chamber summons is incompetent. Can you seek extension? Okay, it appears being logged out from the meeting. Okay, I'm back. So can you extend where a client files an application outside the 1 year or 3 months, whichever is later? Arwa and Change Advocates LLP versus Muturi, where okay, hiyo ndio nimesema that the chamber summons will be incompetent. So let us see other decisions. Mandatory judge plus 2 assessors composition. A section 45(2) challenge must be heard by a judge sitting with 2 qualified assessors appointed through the registrar or LSK process. There is a decision, Nancy Wanjaga Tabaki, a 2012 decision. Then courts will vary or set aside where the fee is manifestly excessive or unreasonable. So this is a draft of the chamber summons to set aside or vary a fee agreement. Now we are advising the client. You have noted that they are within the timeline. Okay, so confirm the agreement meets section 45 formalities. What are the formalities? Has it been signed and executed? Okay, if not, then it is invalid. Is it in writing? Okay, then that is a valid one, section 45(1). If valid, file a chamber summons under section 45(2). Okay, ni kama napoteza nini connection. Okay, so you have been told by the examiner, kindly advise the client to have fallen out with their advocate when it comes to a certain written fee agreement. So this is what you will draft in the High Court of Kenya, in the Republic of Kenya, in the High Court of Kenya at Nairobi, miscellaneous application in the matter of the Advocates Act. Okay, section 45, and in the matter of an advocate client remuneration agreement dated this date, between the client's name and the advocate that he or she is suing. The enabling provisions, we have seen that it is under section 45(2) and section 45(2)(a) of the Advocates Act and order 52 rule 3 of the civil procedure rules. In fact, it is the order 52 rule 3 of the civil procedure rules that says that these applications should be written in the matter of an advocate client remuneration agreement dated this day. So an examiner can give you 1 mark if he is able to see that you know how to give this application a title, because it is provided. So chamber summons, you use the name "let all parties concerned, let the respondent attend the honorable judge in chambers on this date for the hearing of the applicant's application for orders that ban the advocate client remuneration agreement dated this day between the applicant and the respondent be set aside, or in the alternative be varied, substituting the agreed remuneration of shillings with such sums as the court deems fit. In the alternative, the cost in question will be taxed by the registrar in accordance with the applicable and advocate's remuneration order. Cost of this application will be provided for. What are the grounds? The agreement is harsh and unconscionable, exorbitant, and reasonable within the meaning of section 45(2). Then B, the fee claimed is disproportionate to the work done, complexity, time, value of the subject matter, and or outcome. C, the application is within time under section 45(2)(a) because you give the reason why you are within time. Okay. What is the supporting affidavit? Supporting affidavit, you are supporting the grounds that you have listed in the chamber summons. Section 46, invalid agreements. Nothing in this act shall give validity to the following: any purchase by an advocate of the interest or any part of the interest of his client in any suit or other contentious proceeding, or any agreement relieving any advocate from responsibility for professional negligence or other responsibility to which he will otherwise be subjected as an advocate. C, Any agreement by which an advocate retained or employed to prosecute or defend any suit or other contentious proceeding stipulates for payment only in the event of success in such suit or proceeding, or that the advocate shall be remunerated at different rates according to the success or failure thereof. Champion T. Okay, it is illegal in Kenya. So Section 46 declares that agreement invalid. Any agreement by which an advocate agrees to accept, in respect of professional business, any fee or other consideration which shall be less than the remuneration prescribed by the RO, okay, that will be an invalid agreement. Any disposition, contract, settlement, conveyance, delivery, dealing, or transfer that is under the Insolvency Act void or ineffective against the official receiver or a bankruptcy trustee or an interim trustee in proceedings under that act. Okay, so we can say that actually how we have interpreted it so that the content ibaki kwa kichwa. You can say that Section 46 of the Advocate Act, an examiner can tell you that kindly list down the various invalid agreements that an advocate should not engage in. Champeti, or purchase of client's interest. So I propose, because to a champeti, we go with the purchase of client's interest. No validity to an advocate buying the client's interest or part in a suit or contentious proceeding. Okay, here by the end of the other name of champeti, you are purchasing a client's interest. So you'll have an interest in that matter. That will be legal. No contracting out of negligence. No validity to any agreement relieving an advocate from responsibility for professional negligence or other professional responsibility. Unaweza letewa question mwambie the advocate and the client have decided to do an agreement in case of any breach thereof or any professional undertaking that you cannot take me before the tribunal. That will be invalid. That will be an invalid agreement. Contingency or success fees prohibited. So this is charging contingency fees based on the successfulness of the matter. Why? It will promote corruption. So no validity to any agreement where the advocate stipulates payment only if successful. Fee limits. No validity to any agreement where the advocate is charging less than prescribed remuneration order made under Section 44 by the CJ for that business, or 2, more than 25% of general damages recovered less party and party cost. So general damages, for instance, I can say that this applies to personal injury claims. An examiner can bring a situation to tell you that a person got injured in a road traffic accident, but this person was awarded a certain amount, but the advocate charged 30%, okay, of the general damages that were recovered. So that is already a violation of Section 46, not more than 25 of the general damages recovered less party and party cost. E. Insolvency carve-out. No validity to any disposition or transaction that is void or ineffective against the official receiver or trustee or interim trustee under the Insolvency Act. So the same agreement will not have any validity or transaction. You cannot cure if a person alleges to enter into an agreement that is against the official receiver, a trustee or interim trustee. So related instruments that are often applied with Section 46, we have fee agreements generally, but subject to Section 46. Then no advocate may agree or accept less than the remuneration order. So this is a reiteration of what you were saying. We have seen a decision where an advocate tried to charge more than 25% on general damages, and then it turned out to be fatal. So power of court to order advocate to deliver his bill and to deliver up deed. So how do courts interpret this part? Section 47 confirms the High Court power to compel an advocate or the advocate's estate or assignees to deliver a bill of cost and hand over client deeds or documents even if the advocate never filed or appeared in any court for that client. Procedural vehicle in the civil procedure rules. We can say that this part, Order 52 Rule 4 of the Civil Procedure Rules empowers the court where an advocate-client relationship exists or has existed to order delivery of cash, account, money, or securities and papers or documents. Application is by originating summons supported by an affidavit, and the court may protect an advocate's lien by ordering taxation or security. Jurisdiction exists even where the advocate never acted in court. The High Court will entertain an originating summons seeking delivery of documents and a bill and will reject jurisdictional objections framed as this is misconduct or wrong forum, where the relief is plainly Section 47 and Order 52. Advocates cannot hold client documents as lien without tax or agreed cost. Courts often order release of titles and documents where no tax or agreed fees exist, or direct the advocate to file a bill for taxation and or account. If you're an advocate, umemaliza a certain conveyancing transaction, you have the original title, that the client can do an application and originating summons to order delivery of documents or deed. Sasa pande yake ni document. Sasa anaenda kuambia court that kindly force this advocate to release my original title deed because for the following reason: one, we don't have any written fee agreement yenye utasema you rely upon. Two, you have not yet taxed the cost of the conveyancing process that you have undertaken. So it is not okay for an advocate to hold the title first. The law says kwanza unapeana title alafu you go and tax. Sasa the question inakwanga, if you release the title, what leverage do you have upon the client? Atapotea na ni ngumu kumpata mtu Kenya akiwa amejificha ameenda, unaona. So in practice, that's why a lot of students are failing this unit, because ground na what is being applicable is different. So this is what an example of an originating summons pursuant to Order 52 Rule 4 in the matter of an advocate-client relationship between client and advocate. Okay. So in the matter of the Advocates Act, you state the Act, you state the enabling provisions, section 47 and 51. 51 ndo tumesema ni ya 47 ndo tumesema ni ya order delivery of bill or deed documents. So how is it is drafted? So originating summons: let the respondent attend the honorable judge in chambers on this date for the determination of the following questions and for orders that: one, that the respondent be ordered to deliver to the applicant a cash account of all monies received, held, and or disbursed on the applicant's behalf in relation to a matter within this date. That the respondent be ordered to deliver to the applicant a list of all documents or papers and or any monies or securities by the respondent. That the respondent be ordered to deliver up to the applicant deposit in court either deeds or documents and papers. So anaweza mpaka sale agreements, original IDs. Remember, you as an advocate, you are entitled to hold clients' documents for more than 10 years. So you only excuse. What are the grounds? There is an advocate-client relationship. It existed. You have evidence. It is the advocate who has possession. Okay. Under Section 47(1) of the Advocate Act, the court has jurisdiction to order delivery of a bill and deliver up any documents, or even where no court business was made. Hata kama conveyancing it apply. Under Order 52 Rule 4, the applicant is entitled to accounts and deliver up papers on documents. Any alleged lien is only protectable through taxation or security directions. In this part, I overheard a certain advocate saying that there is a client who had deposited with him 50 million for a certain project, and later the advocate realized that there is a bank offering good interest, so akafanya a change of bank, so transmission of money from one bank to another. So the transmission was made, alafu the client was duly notified. So the client told this advocate, sasa umeanza kucheza na pesa yangu, kindly return my money. So the advocate akaanza kumchezea, and the advocate did this application, and the client did this application, and the advocate was compelled to release the money, and the bank was also CC'd, so always kuwa an excuse that the money is not there. Kama umekula, misconduct inaingia. Part of Complaints Commission ni part 10. Establishment of Complaints Commission. Haya, this is provided under section 53. Okay. How have I interpreted this part? It is lengthy. Okay. So section 53 sets up the Advocates Complaint Commission as the first line forum to receive and screen complaints against advocates or firms and their staff, investigative non-disciplinary grievances, refer disciplinary cases to the disciplinary tribunal, and make limited monetary on refund or surrender orders that can be registered and enforced like court orders with a high court appeal. Governing rules, section 53. Okay. So we have seen that section 53(4) that the Complaints Commission can reject a baseless complaint, can refer disciplinary offences to the disciplinary tribunal, can handle non-disciplinary complaints by calling for a response, then investigating and making just and proper orders, or advise complainant to go to court. Okay. Hii section lazima tuisome ikiwa yote hata kama ni ndefu, because it usually confuses students. So ADR for non-serious matters, promote reconciliation and settlement. Monetary cap, we can say that the commission has a certain compensation cap up to 100 million. So pursuant to section 53(6). So registration on enforcement, commission's monetary order can be registered with the court and then enforced like a court order. Surrender of undisputed funds or property, may order surrender of refunds or property not disputed by the advocate, not available if the complainant has already filed a civil suit over the same funds or property. Sawa, nataka ushike hiyo part vizuri, because you will not, it is the commission does not have power to order surrender of funds or property where there is a civil suit that has been filed by the same client or complainant before a court. So hapa itasema we don't have jurisdiction. So fee note or accounts audit, may order detailed fee note within 14 days and assess fees if not produced, may investigate advocates' accounts and demand books. So distress warrant, commission may issue a distress warrant to levy sums ordered, and appeal, any party aggrieved may appeal to the High Court, or High Court, the High Court determination will be final. So judicial interpretation, High Court will enforce professional discipline orders as decrees where no stay exists. Appeal does not automatically stay execution. Same enforcement approach applied to tribunal orders adopted as judgment. Successful complainants are entitled to the fruits unless stayed. Okay. So section 53 itself is the statutory gateway for commission handling, referral, and for registration and enforcement of commission compensation orders under section 53(6)(a). So key takeaways: when to file at the Complaints Commission. Client funds or property withheld and you want surrender or refund without immediately filing a civil suit. Fee disputes where you want the commission to compel a fee note and possibly assess fees if advocate defaults. 3. Service or communication complaints that may not raise to disciplinary offense but require corrective orders and settlement, you go to the commission. Clear misconduct or misappropriation and dishonesty, file to commission. Expect referral to disciplinary tribunal. What not to do, trap. If you file a civil suit for the same funds or property, we have seen the commission power to order surrender is shut out. Okay, now lazima tusome section 53 ikiwa full on its own, provided now we have read the interpretation of this part, because in a way it appears the complaints commission is lesser than the disciplinary tribunal, because we can see that this makes a reference towards the tribunal, and it also has a monetary value of 100,000. So there is hereby establishment, there is hereby established a complaints commission, in this part referred to as the commission, which shall consist of such commissioner or commissioners or as shall be. Nataka next to discuss insolvency regulations immediately in Nagonga 6, so we'll stop at this part for today, because basically we have discussed the grapevine of this act, so we'll still make mpaka tumalize tu mwisho. Unaona kuna discipline, I've even cited a certain section to make emphasis, okay? So tutamaliza tu provided we are making progress. So tunamaliza na complaints commission. So this is a commission that has been established under section 53, which shall consist of such commissioner or commissioners as shall be appointed by the president for the purpose of inquiring into complaints against any advocate, firm of advocates, or any member or employees thereof. If a single commissioner is appointed under subsection 1, he shall be a person who is qualified to be appointed as a judge of the High Court under Chapter 10. Occasioning requirements, any person who without lawful excuse fails or refuses to assist the commission when required to do so under subsection 3 shall be guilty of an offense. It shall be the duty of the commission to receive and consider, hapa sasa ndio key. It shall be the duty of the commission to receive and consider a complaint made by any person regarding the conduct of any advocate, firm of advocates, or any member or employee thereof. And 1. If it appears to the commission that there is no substance in the complaint, it shall reject the same. 2. If it appears to the commission, whether before or after investigation, that there is substance in the complaint, but the matter complained of constitute or appears to constitute a disciplinary offense, it shall forthwith refer the matter to the disciplinary committee for appropriate action by it. Okay. C. If it appears, so usually we will discuss now the next one being the disciplinary tribunal. Okay. If it appears to the commission that there is substance in the complaint, but that it does not constitute a disciplinary offense, it shall forthwith notify the person or firm against whom the complaint has been made of the particulars of the complaint and call upon such person or firm to answer the complaint within such reasonable period as shall be specified. D. Upon the expiration of the period specified under paragraph C, the commission shall proceed to investigate the matter, for which purpose it shall have power to summon witnesses, to require the production of such documents as it may be deemed necessary, to examine witnesses on oath, and generally take all such steps as it may consider proper and necessary for the purpose of its inquiry, and shall, after hearing any submissions made to it by or on behalf of the complainant and the person or firm against whom the complaint has been made, make such an order or award in accordance with this section as it shall in circumstances of the case consider just and proper. Or if it appears to the commission that there is substance in a complaint, but that the circumstances of the case do not disclose a disciplinary offense with which the disciplinary committee can properly deal, and the commission itself should not deal with the matter, but that the proper remedy for the complainant is to refer the matter to the courts for appropriate redress, the commission shall forthwith so advise the complainant. 5. In all cases which do not appear to the commission to be of serious or aggravated nature, the commission shall endeavor to promote reconciliation and encourage and facilitate an amicable settlement between the parties to the complaint. 6. If the commission consider that the complainant has suffered loss or damage by reason of the advocate's conduct, the commission may by order award such complainant compensation or reimbursement not exceeding 100,000 shillings. An order made under subsection 6 shall be registered with the court and shall thereupon be enforceable in the same manner as an order of the court to the like effect. 6b. Where the matter before the Commission relates to surrender of funds or property by an advocate to the client, the Commission may order the surrender of all funds or property which the advocate does not dispute, provided that this subsection shall not apply where the complainant has already filed a civil suit against the advocate. An advocate in respect of the same funds or property. 6c. An advocate against whom an order is made under this section and who has not appealed against such order under section 62 may apply to the disciplinary committee for review of the order. So this, we were not aware of this. So an advocate can review a disciplinary commission order to who? To the disciplinary committee level. So we have a complaints commission. An order has been made. The remedy to the advocate is to appeal under the disciplinary committee for review of the order. So the commission may, in hearing of a complaint against an advocate, order such advocate to produce to the commission a detailed fee note for the purposes of taxation of the bill of cost, provided that where the advocate fails to produce such fee note within 14 days from date of such order, the commission may assess the advocate's fee in such sum as it deems fit. 6e. The commission may investigate the accounts of an advocate against whom a complaint has been made, and for that purpose may order such advocate to produce all relevant books and documents to the commission or to an accountant engaged before the commission in that behalf. 7. The commission may issue a warrant for the levy of the amount of any sum ordered to be paid by virtue of this section on the immovable and movable property of the person or firm by whom the compensation is ordered to be paid by distress and sell under warrant, and such warrant shall be enforced as if it was a warrant issued by the court. Any party aggrieved by a decision or order of the commission under this section may appeal to the High Court, and the determination of such appeal shall be final. The commission shall publish a quarterly report as the complainants dealt with it in that quarter is only administrative. So we have some key takeaways. Where do you seek review of a commission order? Of a complaints commission order, you seek before disciplinary committee. Any other key takeaway? You cannot file a civil suit in regards to the same property in the complaints commission. You cannot be awarded a reimbursement or compensation that exceeds 100,000. So those are the key takeaways. So commission can sieve out, can reject. The commission can refer to disciplinary committee kama kuna disciplinary issues arising. The commission ikiona that this person does not have any remedy before us, does not have any remedy before the disciplinary committee, then we can advise him to go to court. Then we also have power to settle this matter amicably through arbitration. So basically, LISPA, that is it. That is the analysis of the Advocates Act. Person to that part. I beg to end the recording. Any comments I greatly appreciate as I end the recording and take a 2 minutes break and delve into insolvency regulations analysis and the draftings that are required. So LISPA, do you have anything to say? So thank you. I've seen your comment. So thanks. Let me save and upload YouTube.